Hi, everyone. Welcome to this session on justice and environmental harm. And thank you to everyone for joining. My name is Roger Duthie. I'm a research at the International Center for Transitional Justice. And I'm very grateful to have the chance to moderate this session with, I think, 2 other speakers on the topic. Before we start, just a reminder that this information is available. These are joining on Zoom, but if you log in, choose the relevant language. And a reminder that this is meant to be a safe space for discussion and exchange and respectful engagement. Just to give you a little background on my organization and perspective on the topic. ICTJ works in countries and communities that are attempting to address the legacies of massive and serious human rights violations, usually in contexts that are transitioning from affected by conflict with authoritarianism, and generally through a range of different measures, including truth and acknowledgement, memory, reparation, reform, and different types of accountability. In our research and policy work, which is where my focus is, we often frame transitional justice in terms of its contributions to broader agendas, including sustainable peace and sustainable development. And so within that framing, we've done a lot of research on topics like conflict prevention and socioeconomic development, and displacement and restorative justice. And all areas in which I think environmental harms clearly have an important role. I would say, however, that at this point, environmental harms is still an under-examined issue within the field of transitional justice in terms of both practice and research. And while there is some research that has been done and there is some acknowledgement of the issue at the global policy level, I don't think we can fully really understand the relationship between justice, peace, and development without changing that. And in practice, I don't think we can succeed in promoting the rights of victims and affected communities, which is what we're trying to do, without addressing environmental rights. So with that, I'm very pleased to introduce our 2 speakers who will lead the discussion. Munini Mutuku is a peace building and transitional justice practitioner. She's currently principal program officer at the Kenya National Cohesion and Integration Commission. And she also serves as a member of the Environment, Climate, and Peace Platform Steering Committee and is chair of the Transitional Justice Interest Group at EnPAx. Natalia Jimenez works at the intersection of environment and conflict transformation in Latin America. Her experience includes participation in the peace process within the ELN guerrilla group and the Colombian government in relation to extractive industries and the preparation of a report to the Special Jurisdiction for Peace in Colombia, requesting recognition of park rangers, nature, and territory as victims of the armed conflict, and she is a founding member of EnPAx. In terms of the format for the session, Munini is going to present a research study that she is doing as part of an ICTJ project on environmental harm, and Natalia is going to speak in some more detail about Colombia experience and content. I may have a couple of follow-up questions, but then we can open it up for discussion. Munini, the floor is yours.
Thank you. Thank you, Roger, and thanks for that introduction. Welcome to everyone here. And today we look forward to looking at the discussion or the ongoing research on transitional justice and environment. So the question is, what is the thesis of this research? Transitional justice can no longer disregard matters within its various instances. It has always been reckoning with the past in order to build a more just future. But we realize that the future cannot be built without confronting the environmental dimensions, the injustices that gave rise to those transitions. So the question has been, what do we consider to be a victim? What do we consider to be harm? What do we consider to be justice? And how does transitional justice respond to that? Within this research, we have used two methods. We have done desktop research, and we have done interviews with practitioners who are in the field so that they can give us insights into the exercise. So the first thing that the paper is looking at is the past and the present wars and how they intersect with the ecosystems or the environment. And we started by looking at what are the ecosystems we can talk about. So I'm going to look at about three. And when we look at the forest ecosystem, we remember the Vietnam War, the Agent Orange that was used to defoliate the forests of Vietnam. And the reason was that the fighters in Vietnam were hiding in the forest ecosystem. And for that reason, we needed to destroy the forest so that we can get fighting teams. Has any justice been done to that ecosystem? Well, there has been efforts. There were local efforts that began in 1978 to try restore the ecosystem. But how much can you restore of a damaged ecosystem by Agent Orange? In 2012, the USA started a remediation program in Vietnam, but it was based at the base where the US fighters were. 2012 and 1971, the realization that we needed to remediate the environment has taken so long. And unfortunately, that is what we have seen has happened in many of the conflicts where the environment has suffered. The mountain ecosystem. In Yemen, we have these two communities that were having a conflict because of the water source. Mountains are often water sources in most of our communities. So in Yemen, this community, the water source was at the mountain. So one community wanted to divert the water source, the other community did not want that, and so a war broke. But not only in Yemen, in Afghanistan, the war in Afghanistan was fought a lot in the mountain region. And so a lot of impacts of the conflict are experienced in the mountain ecosystem. And again, we have the impacts of climate change coming on. And so we're asking, what does climate change mean for the Afghanistan mountains? While we were asking yesterday, what has the conflict done to the mountain ecosystem? The aquatic ecosystem. In many conflicts, rivers and water masses have been used as graves. We have seen that in Rwanda, in Kagera River. We saw that in Colombia, at the Cauca River. We've seen that in Bosnia, where people have been, dead bodies have been thrown into this ecosystem. What does that discussion look like? Does it even in reference to cleaning the river ecosystem or addressing the damage or the harm that has been done? The marine ecosystem. Remember the Persian or the Gulf War, where we had the Iraqis who opened the oil, and we had this oil spill in the Persian, and it was also set on fire. The damage to that ecosystem. We do remember the United Nations Compensation Commission got quite a number of millions of US dollars to help remediate the ecosystem. How much can you remediate? And we are also seeing the ecosystem, the marine ecosystem being impacted again. The Iran-Israel conflict that has been going on. We have seen oil spill that is being reported as late as April this year. And also to talk about the industrial infrastructure. And this is the oil infrastructure, most of the time where it is damaged because of the conflict and the oil spill that goes to the land. So we move from the marine ecosystem, now it is to the dry land, where we are seeing a lot of oil spillage. Talk of cases in South Sudan, talk of cases in Nigeria, amongst other countries. And climate change, once again, we are having a lot of floods because of the climate change impact in South Sudan. So look at that oil spill and look at that flooding that has been caused by the impact of climate change in the same community. So you have what we are calling the toxic floods. How does this discussion show up in the transitional justice process? Does it even show up in a transitional justice process, or do we overlook the climate change impacts that are compounded by the industrial destruction in a conflict setting? And not forget the mines. Every conflict is having mines and unexploded ordinances. And comes climate change and the flooding, And then we're having mines that are being pushed by water to various areas where you could not find mines. Now you find mines because they've moved with the water. There's this discussion again come up into transitional justice. So these are some of the issues that the research is trying to highlight and posing the question, how does transitional justice address these issues? Because these are not only issues of environment, but also there are also issues related to human rights violations and human rights impact of the war compounded by climate change. Talk of mining. This is how mining looks like most of the time. Open pits that are left open that thanks to rain and floods, they get filled up and you're having a disaster because we have all these pits that are filled up with water and they're causing malaria or people are falling into them. But more so when the rivers are diverted into the mines or the mine water is disturbed in a way that is not appropriate and it ends up into our land. Should we call it ecocide or should we call it environmental damage? So, but again, that this discussion also for transitional justice. Talk about the exposure to toxic waste or toxic waste dumping. We have seen this in quite a number of countries. Talk about Somalia, the toxic waste dumping that has happened in the coast of Somalia. You remember the tsunami, where the tsunami was sweeping toxic waste containers at the coast of Somalia, and we saw the effect that had on the human beings, let alone the marine ecosystem within that region. So if we were to have transitional justice process in Somalia, would it actually address this issue? How about the environmental infrastructure, what we have talked about? How does the discussion of the impact of the war on the environmental infrastructure? We have seen what do you call the dam in Ukraine? Yes, we have seen the dam in Ukraine, the ecological impact of that dam, the busting of the dam to the ecosystem, but also to the human beings. Remember, this is within a conflict situation. So the transitional justice process of Ukraine will be coming up. Transitional justice is asking, how does this discussion come into the table? Does it only come as an anthropocentric discussion, or does it also come as an ecocentric approach? Are we only looking at the impact the busting of the dam did to the human beings, or is it also to the ecosystem? Again, remembering that we don't live alone in this planet, we also have non-human beings. So we have been talking about the impact of the environmental destruction to the human beings. We have seen civil war ravaging national parks. We have seen it in Mozambique. We have seen it in Congo. We have seen it in Rwanda, amongst other places. Some of these countries have gone through transitional justice processes of peace building to support the country move forward. Have this discussion about the non-human beings come up. Gender, health, and environmental harm. The research has also looked at the question of health, because a lot of the environmental impacts we have seen end up impacting on the health of the people, and not only the women, but also the men. Bearing in mind that women are often responsible for looking for water and food, amongst other things. For instance, an example, the Ogoniland case, where we have a lot of environmental damage because of the oil pollution in that area. But the women are still looking for food within the same ecosystem. There are communities that live within that region. And current research has shown that the health of the women, there was a research that was done where they took blood samples of women within the region of Bayelsa to try find out what is the impact of the oil pollution on the women in that area. And they found that the blood samples had very high hydrocarbons because of the pollution in the area. And it's not only in a place like, also in a place like South Sudan, where we are having the oil fields, and we have seen reports of women and children who were born with birth defects because of the hydrocarbons, amongst other pollutants that are found within the environment where they access their water, their food, and also the air that they are breathing. And not to forget also the case in DR Congo, where they are reporting that generally the doctors are reporting we are seeing a lot of increase of certain diseases, and we are attributing them to the impact of the mining within the areas. But because we don't have the instruments to prove the research we looked at, say the doctors are saying because they don't have the instruments to really link causal, the causal link. we will say, yes, it is the cause, but we cannot prove it through science because we don't have the necessary equipment. But it is being seen in countries like DR Congo. Again, going back to the women and health issues in the DR Congo because of the same question of mining. So the question is, what have been the threats and the progress that have been going on, especially in the legal and the policy space that could support transitional justice, or transitional justice could actually tap into their strengths so that it can use that to enhance human rights, but also environmental rights and ecological restoration and reparation. First, we have seen the PERAC principles that have been adopted in 2022 for the protection of the environment in relation to armed conflict. There are 27 of them that were developed by the UN International Law Commission. Kyle Brook was very much involved in that. We have seen the policy on addressing environmental damage through the Rome Statute that was finalized and adopted last year, December 2025, by the Office of the Prosecutor of the International Criminal Court. So this policy looks at the 4 crimes of the ICC. How can they help address environmental harm and damage? And I just picked one of the statements that the policy says in terms of practice, especially on material reparation. And it says that the office will adopt environment-inclusive approach to reparations. And it also says that the office will advocate for transformative, collective, and individual reparations aimed at both repairing the environmental damage caused by the crimes in question and mitigating their impact on affected communities. That is the ICC. That is a big strength for the work that we do. But the question again is, how does the implementation come through? The African Union has not been left behind. We have the African Union Transitional Justice Policy that was adopted in 2019. We currently have the second implementation plan of the African Union Transitional Justice Policy that has just been adopted in March this year. And Section 12 of the policy looks at climate and transitional justice and looking at matters environment and how they should be addressed within the transitional justice space. Let me mention that the first implementation plan did not have anything to do with the environment. And the African Union Transitional Justice Policy itself does not address matters environment and natural resources. Despite the fact that the African continent that it speaks to, a lot of the conflicts have to do with natural resources, and the impact of the conflict that we see in the African continent are humongous in terms of environmental damage and environmental harm. We have the ESCAZO agreement that has been adopted within the South America region with 3 pillars of how environmental information is very important for the communities, participation in environmental decision-making, and also access to justice in environmental matters. And one of the things about this agreement is that it talks about environmental defenders and how they should be protected. And just to add that the question is, the implementation of this agreement is another milestone, but it is a plus to the work that transitional justice is aspiring to do within the environment space. Just to mention a few of the policy frameworks and the legal frameworks that are available. Otherwise, Europe has quite a number that are coming up and some that have already come up. Africa has more. The African Commission on Human and People's Rights is also doing quite some work in line to environment and environmental harm and damage to see what can be done to address that. So what is the response, especially from the transitional justice space? Because transitional justice has looked at it, but needs to look at it more. First of all, the research identifies that one of the problems we have with the frameworks is that they are very anthropocentric. The human being is the center of everything. It's not so much the ecosystem. So you can imagine if the ecosystem does not benefit us, we are not cleaning, we are not remediating, we are not conserving, we are not doing, because the system is anthropocentric. So the shift, the paper argues that we need a shift that balances the anthropocentric and the ecocentric so that ecosystems are restored for the benefit of their own selves, not because they benefit the human being. And their existence is part of the existence of communities. And we cannot overlook the fact that communities have spiritual and cultural relations with ecosystems, even if they are not extracting and benefiting in terms of material from those ecosystems. And another challenge that the paper highlights is that victimhood is always human. It's always the human being is the victim. So transitional justice largely talk about the victim as being the person. And so many times you're looking at people in political rights for the person. Now the transitional justice has progressed, and we are now looking at economic, social, cultural rights in reference to the person. So now we need to move to the next level and look at the environment, of course, in relation to the person, but the environment in relation to its own environment, to its own, for its own benefit, not for the benefit of the human being. Truth commissions, we have seen the Sierra Leone Truth Commission. It was actually one of the first truth commissions to investigate the role of natural resources and the environment in the Civil War, but it did not frame its recommendation or its work in terms of ecology or environmental restoration, but it did recognize the role of natural resources in that war. Timor-Leste Commission for Reception, Truth and Reconciliation, 2002-2005. This was a post-conflict truth commission, and the Sierra Leone was also a post-conflict truth commission. The Timor-Leste Commission had no environment mandate, but is the first commission with a recommendation on the right to sustainable environment, which associates the damage to the environment with the right to health of the population that was impacted. So it actually goes ahead to give a recommendation to UNEP, calling upon the United Nations Environmental Programme to undertake a post-conflict environmental study for the region, so that they, as part of truth telling, what is the truth about the environmental damage that we are talking about? Do we have a report? So one of the recommendations says, UNEP, can you give us a report so that we can know how to move forward if it's in reference to reparations, restoration, or other activities that we would like to undertake. The Tunisia Commission, which is a post-authoritarian truth commission, also did have an element on environment. This commission looked at, it broadened the concept of victim. So it looks at the victim as a person, groups of people, as a legal entity, or a region. So it comes up with the concept of victim regions. And it says the victim regions are every region which was marginalized or which suffered systematic exclusion during the time it is addressing in terms of transitional justice. So it widely acknowledges the pollution that happened during this time and the exclusion of these marginalized regions. And then it gives us symbolic reparations like creation of public memorial, official apology to the victim regions, and commemoration days for the victim regions. But you want to reckon that the approach is very anthropocentric. So it's about victim regions and addressing the injury to the human beings in the victim regions. So the victim regions, the pollution about the people, the health about the people, but it barely has an ecological angle to the approach of victim regions. So assuming it focuses the reparation towards an ecological angle, it would probably honor the victimhood of non-human beings within the victim regions. And also, it would have recommended the adoption of eco-sensitive approaches in the development plans of the victim regions, but it did not. It's very anthropocentric in how it looks at it. Colombia, the big story or the big player in this space in terms of environment. Colombia is a post-conflict, there's a post-conflict truth commission that talks about territories. So it has an ecocentric approach towards the territories. The special jurisdiction for peace grants particular ecosystems like River Cauca and territories like Katsasu legal standing as direct victims of the war, entitling them to truth, justice, and restorative reparations. And we need to reckon that the goals of reparations can be diverse, as we see. When it comes to the Colombia Truth Commission and the judicial process for the transitional justice, it aims for ecological and cultural restoration. But when you look at Tunisia, it operates more as aiming to reverse historical economic exclusion through targeted state investments and development and public infrastructure. It's not so much an ecological approach to the victim region. Third generation commissions. These are commissions that are not addressing post-authoritarian, neither are they addressing post-conflict. You find this commission in Canada, in Finland, Sweden, Norway. So in Canada, the Truth Commission in Canada has 92 call to action, 92 calls to action. And within the calls to action, there's a call to action number 92 that calls upon corporate sector in Canada to adopt the UNRIP, the United Nations Declaration on the Rights of Indigenous Peoples, as a reconciliation framework, and it should apply its principles when it's dealing when corporates are undertaking activities involving Indigenous peoples, their lands and their resources. Question is, what does the DRIP say, the United Nations Declaration on the Rights of Indigenous? In a snapshot, it says that environmental protection and conservation, Article 29, mandates Indigenous people to have the right to conserve and to protect. It talks about spiritual and generational ties, Article 25, the ties that Indigenous people have with their lands and their natural resources. It also talks about consent to participate. Indigenous people have the right for free, prior, and informed consent for activities to be undertaken in their land. It also talks about restricting the dumping hazardous waste in the lands of Indigenous peoples, and also redress and mitigation. That is what the DRIP is. So the action point number 92 under the Canadian Truth Commission expects the respect of UN DRIP in reference to this point. The Finnish Truth and Reconciliation Commission had an objective that supported the ability of the Sami people to maintain and develop their own language and culture, including traditional livelihoods. At the core of which is the connection to land, water, reindeer farming, fishing, amongst others. So if you look at the recommendation of the Finnish Truth and Reconciliation Commission, you will find quite a number of recommendations that talk about the natural resources of the Sami people who have been marginalized for a long time within the Finnish area. So the question is, how does this look in practice? When it comes to truth-telling, like I was saying, the other commission that requested for a report, truth-telling, the UNEP reports are very important, amongst other reports that are being now done by civil society, looking at what is the truth, what is the situation of ecosystems we are talking about. And most of the UNEP reports are usually requested by the states. So the states, a number of states have requested for these reports, and they have been done. The question is Transitional Justice using those reports to inform the work that it is doing on matters environmental reparation and addressing environmental harm? Ecological reparations, a case in point, a far-fetched case in Rwanda. During the Rwanda genocide, we saw destruction of the ecosystem, though it was not on the front line. In the front line of the Truth Commission was human rights abuses, political, and the civil rights. But there were ecological issues that were going on. So there was damage to the Gishwati. I'll just pick two ecosystems, but the wetlands were one of them, amongst others. The Gishwati Forest and the Akagera National Park. There's this model that Rwanda uses, the Umuganda model. It's where they have the cleaning days every Saturday. Once a week, the entire country, the cities are cleaning. So they have used that model to also support the restoration of the ecosystems. And they've used that model to see that the Akagera National Park is restored. They plant trees, amongst other things. And also the Gishwati forest has been restored through the same community participation kind of model to support the restoration of the ecosystems. Remember, this is being done almost many years later. That's when we come to realize, the ecosystem was also damaged and injured, especially because of displacement of people. And then they settled in areas where there were sensitive ecosystems. And because they have to live, they have to eat, they have to live in houses, then we deforest and we use those ecosystems in a way that is not sustainable. Are there challenges to transitional justice? Yes, there are challenges. And one of them is the unprogressive frameworks that we see. For instance, the investor-state dispute settlement system. Now, this system takes cases, is a legal mechanism that allows foreign investors to directly sue a host government in a neutral binding international arbitration. So if I'm a company, I want to do a project in Congo, and Congo does not obey the agreement we had, I can take them to ISDS. So what is happening is that Glencore in 2021 has taken Colombia to the ISDS. And the reason is because Glencore had an agreement that they can mine in Colombia. So the people said, no, you're not going to mine here. And they wanted to divert our water system so that it can go to the mines so that they can use it. Say, no, you're not going to divert the creek and you're not going to mine here. So the people went to court, and the court stood with the people and said, oh yeah, we are going to preserve the ecosystem. We are going to protect the environment. So Glencore goes to the ISDS and sues Colombia because when mining companies to challenge injunctions that held expansion to demand water source protection, and all the efforts that the transitional justice process has put through to protect the environment, to give the river rights, to give the ecosystem rights to justice, could be impacted negatively if Glencore wins this case. If anything, Colombia will be asked to pay millions of money because Glencore will be claiming, oh, our infrastructure, we came there, we are a company, we set up, we were to make so much profit. The cases we've seen, the companies are also claiming we were to make so much profit, so you have to pay us so much as damages for us not being able to mine. So that's one challenge that transitional justice could be facing within this space, amongst other challenges. So in a snapshot, that is not the entire research, but just to create a picture of what the research is doing and what the research is advocating for and the points that it's bringing to, so that we can see as actors within the sector of transitional justice and environment that in post-conflict, post-authoritarian societies, the environment cannot be left behind, because how do we settle people back in systems and in ecosystems that are not functional? Thank you so much.
Thank you so much, Nini, for giving a great snapshot overview of the environmental impacts, the legal and policy framework, the transitional justice response or lack of response, and some of the explanation for why there's a lack of response, and some of the challenges as well. Natalia, I will give you the floor, and if you could dive into the contact.
Thank you. Well, you have heard that the Cauca River in Colombia has been named as victim of, as victim. So it's a big river that crosses almost all the country. It has 1,000 of kilometers. Yes, 1,000 of kilometers. And it goes across many communities, mainly Afro-descendant and indigenous, who from the beginning of this history have been very close to the river. They used to be like the places where they dance and where they like here connect and trade. Regarding the difficult geography we have in Colombia, but I'm gonna tell you a little bit how we get to that point to have a river that is a victim. We have a long story. I'm a lawyer, so I'm gonna put a little bit of focus on the legal history of how we reach that point that was legally possible in our country. So Colombia has a history of almost 30 years of at least 10 peace processes. So the most important peace process was with the FARC because of the importance of the actor, like the former guerrilla, the more armed and powerful, and the guerrilla that controls more the narco traffic in Colombia. So it was a very important transcendental process. But we have almost 10 peace processes that came from the 80s. That's why we have a current former guerrilla president. Former guerrilla president. During these 30 years, we have been in constant transition, in a permanent transition. So with every process, we have gained a little bit more of rights. So the Afro-descendant had their own law. The Natural Resources Code came during the 90s, 80s, late 80s to the legal frame. And at the beginning of the 90s, in 1991, we have like a big peace process that came, we call it like that, because it was a national agreement that changes our constitution. And we consider that like the biggest opportunity of all the people who are in this conflict to bring their own interests to the seat and to the table. And the opportunity for many guerrillas to be in peace, because the Constitution included a lot of dispositions related to environment protection. That's called like a green constitution, and a lot of rights for communities in terms of equity, in terms of development, new courts, new legislation, and power at the very local territories. So we are always proud of our Constitution. So the Constitution says that we have 3 different levels of rights. The first level, the second level, and the third level. The first level are the more urgent, like life, health, education, education. And the third, which is where nature are located. And through the time, we have been considering that nature is connected with the first level of rights because of the relation that has been already recognized in our legal system. So that connection has been always recognized. So for Colombian, the legal process, the legal frame always has been recognized the relation people have with the territory. That's not new. That didn't come with the peace process. So that connection was broken because of the conflict. And what it came with the peace process was the need to restore that connection. Okay. So when we came to the peace agreement with the FARC specifically, what does it say the agreement related to environment? So they say we were going to comply the Constitution. So we will start from there. We will start to see that we need to reconnect communities with the territories, and that will be how they will address the needs and the specific characteristics of the territories and their communities in order to guarantee a long-term sustainability, environmental sustainability and social environmental stability. And the agreement with the FARC says that in order to change the crop of coca, they won't be able to expand to crop other kind of things, and there will be a special protection to national parks, to protect the victims. They established the system of true justice and reparation. So it came from the 5th point of the agreement. We have 6 points, but specifically the 5th was focused on victims. So the justice, the special jurisdiction for peace comes as a right of victims to know their right, the truth, but also to claim reparations. Okay? So this tribunal opened 11 cases, focused on main dynamics and big behavior and the general behaviors during the conflicts. And 3 of those 11 cases are located specifically in 3 areas of Colombia that all of them crossed by the Cauca River. So that was declared as a victim. So that's why the Cauca River became important, and they also use another ratio that I'm gonna share with you. But also in other of the cases that are not explicitly studying the dynamics in those local areas, there are other cases, just like the 11, which is focused on gender-based violence, that is focused on understand the logics of the violence against women, and also that's where the gender dimension came and they are knowing now that more than just being victims, there are relations of power that sustain those dynamics in illicit mining, illicit exploitation of like wood and wildlife. So for many people in Colombia, the environmental perspective are only focused on the territorial cases. But my perspective is that environmental dynamics of the conflict should be addressed in most of the cases. Okay. So what the HEP are supposed to do? So the HEP is supposed to do something called like proper sanctions. The commanders, the high commanders of the guerrilla are responsible for those 11 cases studies. The rest are not responsible. The rest militia are not responsible. So that was a good point of discussion with the guerrilla. But we have dissidents 10 years after the signing the process, the peace process. And these dissidents are almost 4,000 people that came from the FARC that reject the peace process and are starting new activities, illicit activities in these territories. So what happened? We have a strong ordinary environmental legal framework, very strong. Even before the peace agreement with the FARC, we had at least 30 sentences from different courts recognizing nature as subject of rights. That came as recognition of damage and environment or the recognition of the broken relation between communities and the territory. So, for example, one of that is the sentence of Amazon that protects the Amazon as subject of rights, or the Atrato River, which was the first river declared as a subject of rights, because that was the damage of the river and the relations that the court said this river needs to be protected or needs reinforcement in its protection in order to reestablish the relationships and the biocultural dynamics that happen all the time on the river. But this river was not that much characterized as the Cauca. I'm gonna show you why the Cauca River was. What was the step that the HEP made from the ordinary legal frame to the transitional justice? So it was a river that was converted into a buried place. It was like the cemetery, the common cemetery. So people stop allowing going to the river to dance, to cook, to wash clothes, to transport or to trade, because they were looking all the times bodies going down the river. So that was one of the reasons or the evidence that the tribunal found to bring to the next step, the analysis from subject of rights to make a river a victim. The second reason was the fact that the pollution that the river has was also coming from illegal activities, such illegal mining. And the laboratories that came from that they were using chemicals for narcotraffic. So as the sociocultural dynamic that changed and started new ways of violence, and was also part of the scenario on the river. So that was the third reason why they decided to declare the river as victim. And the specific impact on communities with ethnic roots and the broken cosmovision. That's what we also learned, and also the fact that they were catched to join the guerrillas. So that's also part of the broken relations inside the community. So those arguments, those reasons, those evidence, I mean, were enough to create the river as victim, and going from subject of rights in the ordinary to the transitional justice. So we have many other nature places protected as subject of rights, and legally we need to bond the social dynamics in the territory in order to create them as subject of rights or victims. So that's confronting a little bit the perspective of anthropocentric. Thank you. Anthropocentric vision and ecocentric vision. Because legally in Colombia, we have an anthropocentric vision. But it's because we protect the relation, not the focus is the relation between the community and the territories. So that's how the nature can be protected, because there are related in places more to the social dynamics than other places. Okay, so parallel to the peace process, we have a new criminal code that for the first time we include crimes against environment as part of the criminal law. And that is very important, because as dissidents and the deforestation, illegal mining, and other illicit activities persist after the peace process, we needed to manage those dynamics also on the ordinary legal frame. And as the land has been the core of the conflict with many of the criminal bands, we needed to keep that somehow control on the ordinary legal frame. What else should I say? So there are many judges at the head saying we don't know how to bring new philosophical or moral discussions in order to amplify the discussion on how to protect the environment, taking into account that we have such a strong legal frame. But they are doing other things in terms to achieve or bring evidence of the connection to the conflict. They have different commissions, and they have a specific commission of environment that is looking for that kind of answers. And they produced recently a report that says that there are 44 species of animals that are in danger because of the conflict, and the same. What were the evidence they found? That they were used as transport, as bombs, as messengers. And they have a list of use of animals for conflict. So they found evidence to say that there are at least 44 species that are in danger because of the conflict, and the extinction. The danger of extinction is due to the conflict. So the challenge is that find evidence to connect the damage or the threat with the specific dynamics of the conflict. So that was an assertive point from the jurisdiction to choose the territorial cases, because that implies that the study is exactly on the dynamics of that territory, not in general. I forgot to mention something. When we had that many other processes before the peace agreement with the park, we were tired of peace. A lot of people is tired of peace, right? And that's true. That's a reality in Colombia. It's still hard to talk about peace. It's like, oh, again, you're coming with this. And when the peace process was signed, the president in that moment, which is the Nobel Peace Prize president, put a referendum to all the citizens to consider if we agree or not with the peace process. And you know what won? The no. The no one. So that's a reality in Colombia, that we said we have such a strong legal frame. We have already protected many areas. We have a very recent constitution that promotes a lot of rights and procedures. And we still have to negotiate with these criminals. But despite the no, the agreement was implemented. So the majority of people in Colombia still believe that the transitional process has a lot of challenges to make it transcendental or important. Like a lot of people say, we have a new crime code that are pursuing criminal acts like mining, illicit mining, and trade, illicit trade. We need these kind of things. So the judges are totally like, okay, how we step more, how we move, and how we make the next step. And I have heard from them that they need art and other ways to translate what the victims need and what the reparations in symbolic ways could be to restore the relationships. So that's what it sounds like a good way to repair and to find new ways to understand the reparation and reconnect the people with their territory. So remember that the main objective is to reconnect what has been disconnected, because we are connected with our nature that much that we have a environmental legal frame. Yeah, so I will say that that's the story that brings us to find a river declared as victim. And we don't know what to do with that, but no. I'm saying that the implementation is hard, like because, for example, there was another river that is protected, the Bogota, which was the most polluted river in Colombia. And there was also a sentence from a judge that said everyone should pay attention to the river, all the entities, all the local governments to restore the river. So that's the way probably we should implement the measures to protect the Cauca, no? But also, as it is to reconnect relations, we need more creative and innovative ways to overcome the pain and the loss that is this disconnection. That implies this disconnection. Yeah. I'll say that this is like this.
Thank you so much, Natalia, for giving us that really comprehensive story, I think, of how environmental harm get into a transitional justice process through the Constitution, the processes, the legal framework, changes the criminal code, and so dimensions and the socio-cultural dynamics. It's a really sort of complex set of dynamics. We have half an hour left, so I just wanted to a follow-up question, which you both picks up on. You both kind of left it with some of the challenges. I think you both made a really compelling case for why transitional, what the impacts are on the environment, why transitional justice should address environmental harms. But I'm very interested in maybe a little bit more discussion on some of the challenges that transitional justice will face in doing so. I mean, I can think of, some might be the cross-border dynamics of environmental harm and the national focus of most transitional justice processes, the amount of resources that will be needed to implement restoration projects. Both sort of touched on some of the legal challenges, but are there other challenges to do with political resistance and resistance from the private sector, from corporations? All of the factors that will make it difficult to implement the vision that some of the transitional justice processes are pushing. So, Muni, do you want to post?
Yeah, thank you very much. You've actually stated them. That's yeah. Transitional justice is very national. We are rarely, or in the past, we have rarely seen transitional justice processes that are cross-border. If you remember the case of Sierra Leone and Liberia, those conflicts are very connected, but the processes were distinct. This was Sierra Leone Truth Commission, this was Liberia Truth Commission, and at a certain level, they were not able to share documents and information. So that's cutting off, especially in regions where natural resources don't have nationality. Forests cross rivers, like she said, River Cauca crosses. So the damage to these ecosystems cannot be addressed or has challenges when it is addressed in one area and it's not addressed in that, when it will flow into each other. So that is one challenge. The other challenge is a lot of the extractivism that goes on, especially in conflict countries. And the reality of accountability actors, which the ICC has attempted to respond to in the ICC policy on addressing environmental harm through their own statute. That is a big challenge within the transitional justice space. The human rights framework under the UN gives a pillar on reparations and does state that these entities have a responsibility to repair the ecosystems where they have caused any damage or where they operate. But again, the implementation of that is another challenge. And many a times, conflict countries have very weak systems. So who's going to monitor that? Who's going to ensure that is implemented? And the conflict countries often have systems that are easy to compromise. So also the corruptions that comes into the space and the compromising that comes into the space, whether it's outside forces or internal forces. And also the resources to be able to implement some of these recommendations on environment. And not forgetting how long some of these ecosystems take to repair, like the cleaning of the Persian Gulf, the cleaning of the Niger Delta, which has been done for so long, and they had said that it will take another 30 years to really clean out all that oil damage in that ecosystem. So the time frame for the repair of some of these ecosystems is quite something. Vietnam, we are still seeing the impact of Agent Orange even today, the birth of children who live on ecosystems where people still avoid because of all the chemicals that are poured into that space many years later. But again, the challenge also of sophisticated weapons that continue to be created for war. We are seeing more sophisticated weapons coming on board, whether they are bio or they are technological, and the damage that those weapons are causing to the ecosystems. And I'm not sure the technology or the industrial complex wants to reverse the sophistication of the weapons that we have for war. If anything, it's something to brag about, when you have the most sophisticated weapon that can make the most damage. Because in war, it's about where can I hit hardest and how much damage can I cause to my enemy. And that comes with an ecological impact. So yeah, those are some of the challenges amongst others. Some of them you mentioned, you can.
Yeah. Well, I said that based on our case, the interaction between something I forgot to mention before that is that we have a new jurisdiction on agrarian cases that is also part of the ordinary legal system. And this was designed to solve any dispute related to land ownership. And this is part of the ordinary system. So the interaction between the legal frames and different jurisdictions is a challenge. It's like how the HEP in this case dialogue with the rest of the system and the other way to understand what happens in a local in specific territories. So due to the fact that the 11 cases that the HEPs are studying are focused either on specific territories or dynamics. This is a good opportunity to understand that in a territory where the conflict ends with the FARC, but there are new actors, the new actors should also be included in this discussion. That's why the interaction and the dialogues between the different legal frames and jurisdictions should be strong. And I will highlight something related with gender, which is the 11 case. And this is very important. We have 65 protected areas, and Gisela is coming from the national parks, knows that. And we have new parks very often, and nothing has been representing a better condition for women. Like there's no less levels of violence. There are no less levels of high levels of work or less levels of care. I mean, nothing changes. We have more women defenders, but they are lack of bed, and they are still with the same amount of care activities and responsibilities. So this transitional justice scenario where we are focusing specifically in the dynamics of conflict and violence on women that have an excellent opportunity to understand the dynamics related to environment control and how the power relations also with women and how these power relations allow always the criminal activities, because is that exactly that the connection that exists, that the violence against women in these places, in these specific places, allow activities or generate the conditions for illegal mining, for illegal trade, etc., etc. So I'm surprised because in Colombia we have 32 areas, 65 protected areas or national parks. We have 32 sentences protecting nature as subject of rights, and we have a river as a victim, but we don't have nothing related of the rights of women related to environment. Not even in the ordinary jurisdiction or the transitional. Well, this is some process, but the effect of protect environment doesn't mean nothing for the inequality reality of women. And that's something that should be addressed, and this is a big challenge also that I bring as opportunity at this transitional.
Great. Thank you both. At this point, I'd like to open it up for